The history we are taught is usually made of the names victors and the dates of great battles. True history is the one that unfolded in the silence of closed rooms and in fields where people didn't even have the right to their own names. The system was built to be flawless. It had laws, chains, and legions of those who enforced them. But in even the most rigid structures, blind spots always remain. Moments when human will, cunning, or pure age prove stronger than the paragraphs in law books. Today, we open two cases from the archives that were considered closed for decades. Two people, two entirely different paths, one single drive, to survive where survival was forbidden by law. This is not just a chronicle. It is an exploration of how far a person is willing to go when everything is taken from them, except for their own blood and their right to the truth. Welcome to the Bondage Chronicles. Today, two cases, one final. Let's begin with the first. In 1838, Virginia had not recovered from the panic that followed Nat Turner's rebellion 7 years earlier. Patrols were heavier, punishments were faster. The entire legal architecture of the state had been tightened specifically to prevent enslaved people from accumulating any form of power, economic or personal. Against that backdrop, on a tobacco plantation outside Richmond, a white plantation mistress named Iris Calloway began a concealed relationship with an enslaved man named Elias. When her husband found out, he did not survive the discovery. When the county coroner began asking questions, Iris did not defend herself. She let the suspicion move toward her 17-year-old son instead. The boy had no alibi. He also had no idea what his mother had done. What followed was a legal proceeding, a near execution, and an erasure so complete. The official record plantation contains no mention of Elias at all. The question this history forces is not whether Iris Calloway was guilty. She was. The question is what kind of system produces a woman who poisons her husband and frames her own child as the less dangerous of her available options. Subscribe, because the record was kept deliberately incomplete. Let's return to where it began. The morning of October 1838 was a Tuesday. Iris Calloway was standing at the window of the main house study when the county patrol rode up the eastern road. There were 3 men. They stopped at the boundary fence, spoke briefly with the field overseer, a man named Pruitt, and rode on without dismounting. Iris watched until they were past the tree line. Then she returned to the desk and resumed the household supply list she had been working on before they appeared. Elias was in the tobacco drying barn that morning. His assigned task was to inspect the upper ventilation slats on the barn's south wall, several of which had warped during the summer and were no longer sealing correctly against rain. This was a maintenance task that required him to work at height, using a rope ladder attached to the interior beam. The barn was approximately 60 feet long and 30 feet wide, and the upper slats were accessed from a platform 12 feet off the ground. Elias worked alone. The task had been assigned by Edmund Calloway Sr. in writing, recorded in the plantation's work ledger, and was expected to take the full morning. No other worker was assigned to the barn during this period. The door remained open, as was required by Pruitt's standing rule. No enslaved work was permitted to close a barn or outbuilding door from the inside during working hours. The patrol's presence that morning was not random. Following Nat Turner's 1831 rebellion, the Virginia General Assembly had passed a series of statutes requiring county patrols to conduct monthly inspections of all plantations within their jurisdiction. The inspection was procedural. Patrollers checked that enslaved workers were present and accounted for, that no unauthorized gathering occurred, and that the plantation's work documentation was current. Edmund Callaway Sr. kept meticulous records specifically to minimize the time patrollers spent on his property. The October inspection lasted 11 minutes. Everything was in order. The secondary figures who defined daily life on the Callaway plantation were consistent and known. Pruitt, the overseer, was 38 years old and had worked the property for 6 years. He maintained a record of violations and reported directly to Edmund Sr. There was also Clara, an enslaved woman in her 50s, who managed the house and had been on the Callaway property since before Iris arrived as a new bride in 1829. Edmund Jr. was 17, enrolled in correspondence studies through a Richmond tutor, and spent most of his time in the house or riding the property boundary on a gray mare his father given him for his 16th birthday. He had no responsibilities in the plantation's daily operations. Iris Callaway had been educated at a girls' academy in Fredericksburg before her marriage. She kept a private journal, maintained the household accounts independently of Edmund Sr.'s plantation ledger, and had, in the 9 years since arriving on the property, developed a working knowledge of tobacco cultivation that exceeded what most plantation wives were expected to possess. Edmund Sr. found this useful and occasionally irritating in equal measure. The first recorded friction between Iris and her husband appears in a letter she wrote to her sister in Fredericksburg in the spring of 1837, in which she described the plantation as a place where she managed everything and owned nothing. By the spring of 1839, Iris Callaway had begun visiting the tobacco drying barn with enough regularity that Pruitt noted it in his personal log, not the official plantation ledger, but a separate notebook he kept in his quarters. His entries were factual and brief. April 9th, Mrs. Callaway at South Barn, approximately 40 minutes, no stated purpose. April 7th, same. May 2, May requested the barn work schedule for the following week directly from Elias rather than through the house. Pruitt did not report these observations to Edmund Sr.'s reasoning, which he never committed to writing. Was likely that an accusation of this nature against the mistress of the household required more certainty than he had. He continued logging. Edmund Sr. had begun, around the same period, to spend more time at the barn himself, not because he suspected anything specific, but because the spring tobacco yield was behind schedule and he was monitoring the drying process closely. On at least 3 occasions documented in the plantation work ledger, Edmund Sr. arrived at the barn and found Iris already present. The ledger note only that the inspection was conducted and the work was on schedule. Edmund Sr. made no written comment about his wife's presence. Verbally, according to Clara's later account, given privately, never formally recorded, he told Iris that the barn was not a place that required her attention. Iris told him she disagreed. The fracture between Edmund Sr. and his wife was not new. It had been present in some form since the early years of the marriage and had deepened after Edmund Jr.'s birth in 1821, after which Iris had no further pregnancies. Edmund Sr. had comments about this to at least 2 neighbors, documented in later court testimony, describing his wife as cold and difficult to reach. Iris had made no comparable public statements about her husband. She had, however, removed personal journal from the study desk where she had previously kept it and begun storing it in a locked box in her bedroom. In June of 1839, Edmund Callaway Sr. received a letter from a Richmond merchant to whom he owed a substantial debt on equipment purchased the previous year. The letter informed him that the debt had been sold to a third party, and that the new creditor was demanding full repayment within 90 days rather than the installment arrangement Edmund had negotiated. practical consequence was that Edmund Sr. needed to liquidate assets quickly. He instructed Pruitt to prepare a list of enslaved workers who'd be sold to Richmond Market within 30 days. Elias appeared on the first draft of that list. He was valued at $380. The assumption that Elias's position on the plantation was stable had a specific deadline, 90 days. Iris learned about the sale list from Clara, who had overheard Edmund Sr. dictating it to Pruitt. Iris did not confront her husband immediately. She requested a household financial records from the study, reviewed them over 2 days, and then presented Edmund Sr. with a written argument that selling Elias would damage the tobacco drying operation at a critical point in the season and reduce the year's yield by an estimated 15%, a loss that would exceed the debt repayment value of the sale. Edmund Sr. reviewed her figures. He removed Elias from the list. He did not thank his wife for the analysis. The debt was covered through the sale of 2 other workers and a parcel of the western acreage. Elias remained on the property. The danger had passed. The dynamic between Iris and her husband had not. The summer and fall of 1839 passed without a documented incident. Pruitt continued his private log. Edmund Sr. managed the debt settlement. Edmund junior his correspondence coursework and began spending more time with neighboring families, which reduced his presence on the plantation. The external pressure of the patrol system had also intensified. A suspected conspiracy among enslaved workers on a neighboring property in August had resulted in a county-wide sweep that placed every plantation in the jurisdiction under elevated scrutiny for 60 days. During this period, Iris Calloway did not visit the tobacco barn. Pruitt's log has no entries for August or September. In October, the entries resumed. In the winter of 1840, Edmund Sr. found the locked box. He did not sit open immediately. According to Clara's later account, he asked Iris for the key directly in the parlor in the early evening. Iris refused. Edmund Sr. took the box by force the following morning while Iris was in the kitchen with Clara. He read the journal. What it contained was never entered into any official record. But Edmund Sr.'s behavior in the days following was documented by 3 people independently. He dismissed Pruitt from the property with 1 week's notice and no written explanation. He submitted a revised sale list to the Richmond Market with Elias listed first, valued at $400, with a notation requesting urgent placement. And he told Edmund Jr., in a conversation the boy described years later in a private letter, that his mother had done something that could not be forgiven, and that the family would need to make adjustments. Iris was informed of the revised sale list by Clara on the morning of February 4, 1841. She asked Clara to leave the kitchen. She remained alone in the kitchen for approximately 2 hours. That afternoon, she requested the household medicine chest from the upstairs storage room, a routine action as she managed the household's basic medical supplies. The chest contained, among other items, a quantity of arsenic kept for rodent control, which was standard on Virginia tobacco plantations of the period. The quantity of arsenic in the chest, after Iris returned it, was not measured or recorded. Edmund Calloway Sr. became ill on the evening of February 11, 1814. He was dead by February 4th. The moral question embedded in these 7 days does not resolve cleanly. Iris Calloway was a woman who had been transferred from her father's legal authority to her husband's at the age of 23, who owned nothing in her own name, who could not legally presale of a man she had chosen at enormous personal risk, and who had watched her husband destroy everything she had built inside the constraints the system gave her. She was also a woman who poisoned a man and then allowed her teenage son to bear legal consequence. Both of these things are true simultaneously. Edmund Snur's death was initially recorded as gastric fever, a common diagnosis in the period that covered a broad range of symptoms and required no further investigation. When the deceased was a middle-aged man, the documented history of digestive complaints. The local physician, a Dr. Harlan, signed the death certificate without requesting a coroner's review. Edmund Snur was buried on the plantation grounds on February 17, 1841. Iris, appropriate mourning dress. Edmund Jr. stood beside her at the burial. He had been told his father died of fever. The coroner became involved 6 weeks later. A neighbor, a man named Trescott, who had purchased one of the Callaway parcels during the debt settlement, mentioned to the county sheriff that Edmund had told him in January that he believed his wife was involved in something that could damage the family and that he intended to take legal action. Trescott did not know what specific action Edmund Snur had planned. He reported the conversation because Edmund's death, coming so soon after that conversation, as worth mentioning. The sheriff forwarded the information to the county coroner, a man named Aldis. Aldis ordered an exhumation. The exhumation took place on April 2, 1841. The results were not publicly disclosed immediately, but within 2 weeks Aldis had requested interviews everyone present in the Callaway house during the period of Edmund Snur's illness. This included Iris and Clara, and 2 field workers who had delivered supplies to the house kitchen during that week. Clara was interviewed first. Her account, as recorded in Aldis's notes, which survived in the county court's archive, stated that she had no knowledge of how Mr. Callaway had become ill and that the household had functioned normally in the days before his death. She did not mention the medicine chest. Edmund Jr. was interviewed on April 14th. He told Aldis that he had been in Richmond for 3 days during the week of his father's illness, visiting his tutor, and had returned to find his father already deteriorating. He provided the tutor's name and address. Aldis noted in his records that Edmund Jr.'s alibi covered only 3 of the 7 days that the boy had been present in the house during the period when his father first showed symptoms. Aldis also noted that Edmund Jr. had recently been told he would inherit the plantation and its debts, which constituted a potential motive. Aldis did not note any comparable motive for Iris. She was legally a widow with no independent assets and no ability to inherit property directly under Virginia law. The system's own logic made her appear to have less reason to act than her son. Iris did not correct this assumption. When Aldis interviewed her on April 18th, she answered his questions precisely and briefly. She confirmed that her husband had been ill. She confirmed that she had managed his care. She confirmed that Edmund Jr. had been present in the house. She did not volunteer the information about the medicine chest. She did not say anything that was technically false. Edmund Jr. was formally questioned by the county sheriff on May 3, 1841, and was held for 11 days pending further investigation. During this period, Iris made no public statement. Clara, according to a letter she sent to a free black contact in Richmond, a letter that was intercepted and preserved in a patrol file, wrote that she knew what happened and did not know what to do with the knowledge. The letter did not reach its recipient. It was filed without action. Edmund Jr. was released on May 14th, when Richmond tutor provided documentation confirming the presence in the city during the critical early days of Edmund Snur's illness. The coroner's investigation concluded without a formal finding. The death certificate was not amended. Edmund Snur's cause of death remained listed as gastric fever in the county record. Elias was sold to a Petersburg property in June of 1841, 4 months after Edmund Snur's death. The sale was conducted by the estate's executor, as Iris had no legal authority to prevent it. The sale price was $410. His subsequent history is not recorded in any Callaway document. Iris Callaway managed the plantation until 1847, when she transferred legal control to Edmund Jr. upon his marriage. She died in 1852 at the age of 48. Her death was recorded as heart failure. Her private journal was not found among her effects. Clara died in 1849, still enslaved, still on the Callaway property. She is listed in the estate inventory that year as a household asset valued at $90. Age noted as approximately 60. No last name recorded. Edmund Jr. managed the plantation until the Civil War. He sold the property in 1863. He never publicly discussed his father's death. In a private letter written in 1871 to his own son, he described Mother as a woman who made decisions he did not fully understand until he was old enough to understand what the plantation had cost her. He did not elaborate. The county coroner's file on Edmund Callaway Sr. was archived and later transferred to the Virginia State Library, where it remains accessible. It contains Aldis's interview notes, the exhumation order, and a final summary that lists the cause of death as consistent with natural illness. Elias is not mentioned anywhere in the file. He is not mentioned in the coroner's notes, the estate records, or the plantation ledger entries from the period of the investigation. The system that was built to control him so thoroughly rendered him invisible that his invisibility became, in the end, the thing that protected the woman who had chosen him. Whether that protection was the point, or simply the result, the record does not say. The first case is closed, but the system rarely fails only once. While the first instance showed us a silent siege from within, the second name on our list chose a path that left no stone unturned. Moving to the next protocol. In 1854, a South Carolina plantation owner, Robert Harwell Sr., walked into a Beaufort attorney's office and dictated a will that left his entire estate, land, livestock, and assets valued at approximately $40,000, to an enslaved man named Caleb. What the will did not state directly, but what the attorney understood from the conversation, was that Caleb was Harwell's biological son. The will was legal. It was witnessed. It was filed. When Harwell died 3 years later, his 2 white sons found the document within 72 hours. The attorney who drafted it was gone from Beaufort County records within the month. Caleb was dead within 30 days of his father, listed in the official record as a fever casualty. The estate passed to the white heirs without legal challenge. What this history forces is a precise and uncomfortable question. When a man spends 30 years owning his own child and then attempts to correct it with a single document on his deathbed, is that an act of, or it's simply the last thing the system allowed him to do without consequence? Subscribe, because the record was closed deliberately. Now, let's return to where it began. The morning of September 9th, 1854 was a Saturday. Robert Harwell Sr. arrived at the Beaufort office of Attorney Gerald Morse at 9:30. He had crossed the ferry road from the plantation alone, without his overseer or either of his white sons, which was unusual enough that Morse noted it in his appointment log. Harwell was 61 years old, in declining health, and had made no previous arrangements regarding his estate beyond a standard property deed registered 839. He told he needed a will drafted and witnessed before he returned home that afternoon. Morse recorded the appointment as routine. Caleb was on the plantation that morning, assigned to the rice field drainage that occupied most of the able-bodied male workers during the fall preparation season. His specific task that day was clearing a blocked drainage channel on the eastern field boundary, a job that required him to work knee-deep in tidal marsh water, manually removing compacted sediment and debris from the channel mouth using a long-handled iron tool. The work was documented in the plantation's labor log by the overseer, a man named Vickers, who recorded start time, assigned location, and expected completion. Caleb's entry for September 9th reads, "Drainage, east boundary, full day." He had no knowledge that his father was in Beaufort. Vickers had a standing order, in place since 1851. The worker assigned to the eastern field boundary was to leave that section of the property without written authorization. The marsh perimeter was close to a navigable waterway, and Vickers had implemented the restriction after two workers from a neighboring plantation had used a similar waterway to attempt an escape the previous year. The order applied to all workers regardless of their assignment level. Caleb had never violated it. He had also never attempted to leave the property in the 28 years he had lived on it. Vickers noted no irregularities in his log for September 9th. Secondary figures who defined daily life on the Harwell plantation were consistent and known. Vickers managed all field operations and reported directly to Harwell Sr. There was also a domestic worker named Nora, a woman in her late 40s who had been on the property since before Caleb's birth, and who was one of 3 people on the plantation who knew with certainty who Caleb's father was. The 2 white sons, Robert Jr., 32, Thomas, 28, managed the business accounts and the property's external relationships. Lived in the main house. Caleb lived in the field workers' quarters, in a structure that shared a wall with the tool storage building. Robert Harwell Sr. had been educating Caleb privately since Caleb was approximately 9 years old. This was illegal under Carolina law, which prohibited the instruction of enslaved people in reading and writing. Harwell conducted the lessons himself, in his study in the early morning hours before the rest of the household was active. By the time Caleb was an adult, he could read, write, perform basic accounting, and navigate legal documents. He had never used these abilities publicly. Vickers did not know about them. Robert Jr. and Thomas did not know about them. The knowledge sat in Caleb like a set of tools he had been given, with no explanation of when he would be permitted to use them. The fall of 1854 passed without visible incident on the Harwell plantation. Vickers completed the harvest documentation. Robert Jr. traveled to Charleston twice for business. Thomas managed a boundary dispute with a neighboring property that was resolved through a county arbitration in November. Caleb continued his assigned work. The will Harwell had filed with Morse in September was not mentioned to anyone on the property. Harwell returned from Beaufort that Saturday afternoon and resumed his normal routine. If he told anyone what he had done, it was not recorded. By the spring of 1855, however, Harwell Sr.'s health had deteriorated visibly enough. Robert Jr. had begun making inquiries about the estate. He contacted the family's Charleston solicitor in March and requested a summary of the property's legal documentation, deeds, registered agreements. The solicitor provided what he had on file. The Beaufort will was not the Charleston solicitor's records, because Harwell had filed directly with Morse rather than through the family's established legal channel. Robert Jr. did not know Morse. The gap in documentation did not register as significant at that stage. He noted only that his father had not updated his estate arrangements since 1839, and that this needed to be addressed. Robert Jr. raised the subject with his father directly in April 1825. Harwell Sr. told his son that his affairs were in order, and that Robert Jr. did not need to involve himself. Robert Jr. recorded this conversation in a letter to Thomas, describing their father as evasive and suggesting that his declining health might be affecting his judgment. Thomas wrote back recommending patience. Neither son took further action in 1855. Vickers, who was not party to any of these conversations, noted in his personal log that spring that Harwell Sr. had begun spending more time observing the field directly, walking the property boundary in the early morning, watching the drainage crews, occasionally stopping near where Caleb was working. Vickers recorded this as the behavior of an aging man reviewing his property. He did not assign it further meaning. In January 1856, the South Carolina legislature passed an amendment strengthening the state's existing restrictions on manumission, the legal freeing of enslaved people. The amendment closed a procedural gap that had previously allowed plantation owners to free enslaved individuals through testamentary bequest, meaning through a will. Under the new provision, any such bequest was automatically void unless accompanied by a separate legislative petition approved by the Assembly, a process that took a minimum of 2 years and was denied in the overwhelming majority of cases. Harwell's 1854 will had been drafted before this amendment. Its legal standing under the new provision was uncertain. Morse, the Booth attorney, was aware of the amendment. Whether he informed Harwell is not documented. The amendment did not change what Harwell had written. It changed what the document could accomplish. The $40,000 estate bequest remained legally contestable. The property transfer remained theoretically possible if challenged through the right channels, but the practical for Caleb to receive anything through the will had narrowed significantly. Harwell, now 63 and in worsening health, had 2 options: pursue the legislative petition immediately, which would make his intention public and force consultation with his sons while he was still alive, or leave the will in place and hope the document's existence alone would be sufficient. He chose the latter. This was the first irreversible step, not Caleb's but his father's. The spring and summer of 1856 moved under a changed weight. Harwell Sr. began spending time with Caleb in the evenings, not in the main house, but at the edge of the eastern field, in conversations that Vickers observed from a distance and did not approach. Nora, who saw more than Vickers, later described these conversations as the kind 2 people have when one of them knows time is running out. Harwell said nothing to his sons. Caleb said nothing to anyone. Robert Harwell Sr. died on March 3, 1957. The cause recorded by the attending physician was cardiac failure, consistent with his documented health history. He was buried on the plantation grounds 2 days later. Robert Jr. and Thomas managed the funeral arrangements. Caleb was present at the burial as part of the assembled household. He stood at the back of the group. No one recorded his presence specifically. Robert Jr. moved to obtain estate documentation within 48 hours of his father's death. He contacted the Charleston solicitor on March 5th and requested a full legal inventory. The solicitor confirmed that the only registered estate document in his files was the 1839 property deed. Robert Jr. then asked whether his father had engaged any other legal counsel in recent years. The solicitor did not know. Robert Jr. asked Vickers the same question. Vickers recalled that Harwell had made a solo up to Beaufort in September 1854, but had no knowledge of its purpose. Robert Jr. traveled to Beaufort on March 6th. Gerald Morse confirmed the existence of the will when Robert Jr. presented himself at the office. He had no legal basis to withhold the information. Robert Jr. was the deceased son and the estate's presumptive heir. Morse produced the document. Robert Jr. read in Morse's office. He did not speak for approximately 2 minutes after finishing. He then asked Morse how many copies existed. Morse told him the document in his hand was the only copy, the filing copy. Robert Jr. asked whether the will had registered with the county courthouse. Morse said it had not yet been submitted for probate, as the death had occurred only 3 days prior. Robert Jr. took the document from Morse's desk. Morse did not stop him. The will left Beaufort in Robert Jr.'s coat pocket on the March 6, 1857. What happened to the document after that point is not recorded. Robert Jr. returned to the plantation on the evening of March. Thomas was informed of the will's contents that same night. Both men were present when Vickers was summoned to the main house the following morning and given instructions regarding Caleb. The instructions were not written down. Vickers' plantation log contains a single entry. Worker Caleb removed from field assignment pending review. No reason is stated. No authority beyond Vickers' own notation is cited. Caleb was confined to a storage structure on the property's north end on March 8th. The fabricated charge, recorded in the county sheriff's intake documentation on March 10th, when Robert Jr. formally reported the matter, was theft of plantation property. The specific item allegedly stolen was a quantity of iron tools from the equipment store. The intake record lists the reporting party as Robert Harwell Jr. and the accused as Caleb, enslaved property of the Harwell estate. No witness is named. No evidence is described beyond Robert Jr.'s statement. The moral question that Harwell Sr. had deferred for 30 years arrived on March 8th with complete clarity and no available remedy. Caleb. Harwell had told him about it in one of those evening conversations at the field boundary. Not the legal details, but the fact of it. He had told Caleb that he had tried to do something. Caleb now understood precisely what that something had been worth. The county sheriff's office processed Caleb's case on March 12, 1857. Under South Carolina law, an enslaved person accused of theft from their owner's estate had no right to legal representation and no right to present a defense through testimony. The adjudication was administrative. The sheriff reviewed Robert Jr.'s statement, noted the absence of contradicting documentation, and remanded Caleb to county custody pending a determination of punishment. The standard penalty for the documented charge was public flogging, followed by return to the owner's custody. The Harwell brothers, as estate heirs, were the legal owners. Gerald Morris did not report with the county courthouse regarding the will. He did not contact the sheriff. He did not produce a secondary record of the document's contents. His appointment log for September 854, the entry that recorded Harwell Sr.'s visit, was the only surviving mention that the will had ever existed. Morse left Beaufort sometime in late March or early April 1857. His forwarding address was not recorded with the county clerk. His office lease was terminated by the building owner in April after Morse failed to pay the quarterly rent. His whereabouts after 1857 are unknown. Nora attempted to reach Robert Jr. on March 14th. She requested a meeting through the household standard protocol. A written request submitted to Vickers delivered the request. Did not grant the meeting. Nora's subsequent actions are not documented. She remained on the property. Caleb was returned to Harwell Plantation custody on March 15th, following the county adjudication. The punishment had been administered. He was placed back in the field worker quarters. On March 19th, Vickers' log records that Caleb was moved to the infirmary structure due to illness. The attending notation reads, fever, cause unclear. On April 4th, 1857, the log records, worker Caleb, fever. He was 31 years old. He is not buried in the plantation's documented burial ground. His grave location is unknown. The confrontation that defined this history was not dramatic. It did not involve raised voices or open violence in any form that was recorded. It involved a man reading a document in an attorney's office and putting it in his coat pocket, and a system that required nothing further from him after that moment. The cruelty was not in what Robert Jr. did to Caleb directly. It was in what the system made unnecessary for him to do at all. The Harwell estate was probated without contest in May 1857. Robert and Tim Hamas divided the property according to the 1839 deed, which named both sons as equal heirs. The estate was valued at $42,000 in the probate inventory. The inventory lists all assets including the enslaved wares on the property, categorized by age, physical condition, and assigned role. Caleb is not listed. He had died before the inventory was compiled. His absence from the document is recorded only as a marginal notation. One worker deceased prior to assessment. Robert Jr. managed the plantation until 1861, when the Civil War disrupted low-country rice production permanently. He sold the property in 1863 at a significant loss. Thomas had relocated to Charleston by 1860 and is listed in city directories as a merchant. Neither brother left any written account of the events of March 1857. Robert Jr.'s personal correspondence, a portion of which was donated to a South Carolina historical archive in 1910 by his grandson, contains no reference to a will, to Caleb, or to Gerald Morse. Morse's appointment log, the single document confirming the will's existence, was found in 9/2023 in a collection of miscellaneous legal papers purchased at an estate sale in Columbia. The log is now held by the South Carolina Historical Society. The September 9, 1854 entry reads, A Harwell Sr. Beaufort Ferry Road, Testamentary Instrument 1 copy witnessed. The Society's catalogue describes the log as a routine example of mid-century legal practice records. No annotation connects it to the Harwell estate or to Caleb. Nora died on the Harwell plantation in 1861. She is listed in the final plantation inventory before the sale as a domestic. Age approximately 58, value assessed at $40. No last name recorded. The 1854 will no longer exists in any form that can be legally verified. The appointment laws it was drafted. The probate record confirms it was never submitted. Everything between those two facts, what Harwell told Caleb, what Morse understood, what Robert Jr. did with the document in the hours after he left Beaufort, exists only in the gaps the official record left open. Robert Harwell Sr. spent 30 years owning his son, and one afternoon trying to undo it. The system required his sons less than 72 hours to ensure that afternoon meant nothing, whether that outcome was inevitable from the moment Harwell child chose silence over 30 years. Only from the moment he chose a will over a legislation. The record does not resolve.